I think we can start now. Hello all, my name is Bryn and I'm the Membership and Event Coordinator for the Life Science Cluster. The Life Science Cluster is a network for all companies and organizations that are involved in life sciences, like the health sector, marine sector, agriculture and forestry sector. If anyone here would like to receive more information about the Life Science Cluster and what we do, please don't hesitate to contact us. Now that was a very short introduction to the Life Science Cluster. I wish to welcome you all to this webinar, and I hope you will learn some new and interesting things about trade secrets today. I'm happy to introduce Håkon Tysnes Kaasin, who is a very experienced attorney at law. Håkon specializes in IP, and he has represented some of the world's largest brand owners before the Norwegian courts. Feel free to use the chat when you wish to ask questions during and after the presentation. The questions will be read out loud during the question round. I would also like to notify you that the webinar will be recorded. So Håkon, the stage is yours.
Thank you, Iselin. Every child knows what a secret is and what to do with it. The problem is that it's just not that easy. And once you've told one, the damage may already have been done. Welcome, and thank you for joining us this morning. My name is, as Iselin said, Håkon Tysnes Kaasin, and during this webinar, you will learn what a trade secret actually is, what you need to do to protect it, and why it's important to do so. I'll try to use practical examples as much as possible. My goal is that you walk away today thinking that you've learned something that you can actually implement in your daily business. This presentation will be about 25 minutes, and we will then have a Q&A session at the end. But feel free to ask questions via chat during the presentation, and we will answer those at the end. First, just a little bit on my background and why I'm the one speaking to you today. I'm a lawyer specializing in intellectual property, and I've been working with IP for almost 15 years now. Previously, I worked as managing attorney for Cisco Systems video conferencing division, which was a $1 billion business per year. One of my responsibilities was both inbound and outbound technology agreements. And I worked closely with the R&D department, mainly at Lysaker, but also in Bangalore, San Jose, London, and Galway. I also had to handle a few conflicts with former employees who left the company to start competing businesses, where we nearly ended up in court, both in Oslo and in the US, and where trade secrets played a vital part. I'll get back to that later. Before joining Cisco, and again for the last 3 years, I've been working with Bryn Aarflot. Bryn Aarflot is one of Norway's leading IP consultancy firms, and we have currently 9 lawyers and 15 patent attorneys, and we offer a full range of IP services, including securing, maintaining, commercializing, and enforcing our clients' IP rights. And here is today's agenda. I will start with giving an introduction to the topic of trade secrets before zooming in on the new law that will enter into force next year. We will then move on to take a closer look at what a trade secret actually is and how you can and must protect it. This will in turn bring us to the wonderful world of contracts before we end off with talking about what control measures you should take to safeguard your trade secrets and detect potential infringements. And as mentioned, we will have a Q&A session at the end. As many of you probably know, intellectual property can be protected in a number of ways, with patents and trademarks being the most obvious and well-known options. But today we will focus on trade secrets, as a large portion of a company's value lies in its knowledge and its ability to utilize it. These values will be dramatically reduced if the knowledge becomes common knowledge that everyone can use. So what are we talking about here? We're talking about everything your competitors don't know, but you do, and that makes you better than the others. Some rights are protected through legislation, while others you can only protect by being the best at keeping secrets. High-tech companies go far to protect their secrets physically through encryption, passwords, locks, bolts, and barriers. That's not enough. Far more important measures are to have an IP strategy and routines for contract management, to monitor and follow up that strategy, to build a strong company culture and work environment, and to make sure your employees feel proud of working for the company. But even this doesn't always help. And why? Well, because employees quit. Just by a virtual show of hands here, how many here have changed employer the last 4 years? And those of you with your virtual hands in the air, how many of you have stayed roughly within the same industry or technology? Well, within a 4-year period, 30% of all employees in Norway changed employers, and many of them within the same industry. And regardless of how careful you are, you still know what you know. You can't do a factory reset of your brain. It is incredibly difficult to sit in a meeting with your new employer when someone proposes a solution that you have already thoroughly tested for your previous employer and you know it won't work. Do you sit still and let your new employer waste 3 months on testing? Or do you rather breach your confidentiality obligation and misuse the trade secrets of your former employer? This is a difficult but very common dilemma that many of us will face at some point. Trade secrets is not a new concept, but how we protect them have changed over the years. Some of you may be familiar with the history of the Murano glass. The secret knowledge of how to make exclusive and costly glass was so important to the wealth of ancient Venice that all glass workers who knew the trade secret were placed on the island of Murano, just outside of Venice, with total exit restrictions. They were simply not allowed to leave the island. So you might say that was kind of a very analog firewall. And if that wasn't enough, the penalty for disclosing the trade secret was death. Quite strict, in other words. In return, the glass workers received numerous privileges, for example, legal immunity, well, except for the death penalty, and the right to marry their daughters to the richest families of Venice. What more could a poor glass worker ask for? Fortunately, we don't have to go to those extremes to protect our trade secrets today. A good example of a company benefiting from a trade secret is Coca-Cola. I guess this is a quite obvious example, and there are many myths around this, like it's only 2 living persons who know the recipe and they're not allowed to be on the same flight in case of a plane crash. Coca-Cola has obviously also done a very good job on the trademark and marketing side, but I think it's safe to say that they would not have been in the position they are now if their top secret recipe was public property. And I'm not saying that just because Coca-Cola is one of our big clients. They probably could have patented the recipe back in 1886, but then it would have been public knowledge 18 months later. And by 1906, when the patent would have expired, everyone would be free to use the recipe. That means that everyone could have made the same soda for 116 years up until today. And even with the best marketing strategies, it's hard to imagine Coca-Cola having the market position it has today in such a scenario. Coca-Cola is not just an example of how trade secrets are crucial for how the product itself is produced, but also of the value of basing your entire business on trade secrets. So to pull it back to Norway in 2020, where you are not allowed to execute your employees for breach of confidentiality, what is the current situation and how is that about to change? Well, up until now, trade secrets have been subject to fragmented legislation with no clear definitions. You will find some regulations spread across the Marketing Controls Act, markedsføringsloven, and some in the Penal Code, straffeloven. From the 1st of January 2021, this will change, or at least that's the plan, because that is when the brand new Norwegian Trade Secrets Act is expected to come into force. It is based on an EU directive and means that our law will now be harmonized with EU law, which will make it easier and more predictable to protect your trade secrets when you do business across Europe. The new Trade Secrets Act provides something that has been missing earlier, namely an actual definition of what a trade secret is. And I will get back to that shortly. Furthermore, it includes detailed regulations of which acts will constitute an infringement and also enhanced enforcement regulations. Due to the limited time we have today, I will not touch upon these 2 latter aspects in this presentation. So we'll now take a closer look at what the legal requirements are for something to qualify as a trade secret, because it's not enough that the company itself defines something as a trade secret. There are 3 requirements that all must be met in order for information to enjoy protection as a trade secret under the new law. First, and quite naturally, the information must in fact be secret, meaning that the information as a whole, or how it's compiled or organized, is not publicly known or easily available. Secondly, it must have a commercial impact on your company's business that the information is kept secret. In other words, you would lose a competitive edge if your competitors knew what you know. And finally, you have to take reasonable precautions to safeguard the information to keep it secret. So what kind of information can be considered a trade secret? Well, the options are countless. I just listed a few typical examples here, like market surveys, test results, business strategy documents and plans, customer lists, workflow charts, manufacturing methods, synthetic routes, algorithms, and unpatented inventions. There are many more types of information that potentially could be considered trade secrets. So now you know what a trade secret is, but how do you protect it? The first step is to actually identify your potential trade secrets. During a systematic review, you will most likely find that you have way more potential trade secrets than you thought. You will be surprised by some of the things that you will find in drawers or other file folders of your employees. The next step is to evaluate if they are still secret. What measures have been taken to secure the information? If it has been available to everyone on your website, it has clearly lost any level of confidentiality. But it may also be problematic if the information has only been filed on an internal server without access control, so that all of your employees have access to it. And is it marked confidential? Well, statistically, the answer to that question is no. Finally, you need to assess if additional measures are needed. And based on what I just said, the answer to that question is probably yes. We will therefore now take a closer look at what you need to do to protect your information in order for it to enjoy protection as a trade secret. So what is required to protect valuable information to such a degree that it meets the legal requirements of taking reasonable precautions? To the extent possible, mark the information confidential to signal both to your employees and to third parties that you consider the information to be confidential trade secrets. It will serve as a reminder to your employees, so hopefully your overeager sales rep doesn't forward your entire product roadmap for the coming years to any potential customer. To include a confidentiality notice is easy to do, but just as easy to forget. So try to incorporate this into all your routine description and make it into a habit. No one has ever gotten into trouble from excessive confidentiality stamping of documents. Of course, it's not enough to write that something is confidential. You need to treat it that way too. You should therefore implement access control so that only the people who need access to information have it. Access control can also provide information about who has actually viewed and downloaded the confidential information. And I will soon get back to why that can be very useful information in itself. I know I may have been painting your employees as bad guys so far, but you also need to worry about data breaches, break-ins, hacking, and phishing attempts. It's therefore important to focus on data security and make sure that you have sufficient IT protection. However, that's a completely different topic, and I will not go into details about that today. Finally, the best way to keep something secret is to tell as few people as possible and to tell them as little as possible. Always try to limit the scope of confidential information you share to the bare minimum. But since you will need to share your confidential information with some people at some point, you need to protect your information through agreements. But before I dive into the wonderful world of agreements, I want to spend a few minutes to talk about what you should focus on to establish an efficient protection regime. It is paramount to have a company policy in place for how you treat your trade secrets. More importantly, have dedicated resources to ensure that it is actually followed and kept up to date. This means that you should have one person or function who has the main responsibility for this, to avoid the common, but I thought he or she was responsible for that scenario. The most important thing is to provide training to your employees, as they pose your biggest risk. If you want to really make sure your information is kept secret, you should not have any employees at all, and preferably not interact with any third parties. However, science does suggest that that might be a suboptimal business strategy, so you're back to the need for training. Having said that, you do not need to send your employees back to university. A 30-minute presentation during lunch break or a breakfast Zoom meeting will most times be sufficient. The important thing is to raise the employees' awareness and not to make them into mini lawyers, as some would claim the world already has a way too many lawyers, which I do not agree with. Finally, you need to establish control measures to detect breaches and to be able to enforce your rights. I will talk more about that towards the end of the presentation. Now I will proceed to talk about how you can protect yourself through agreements. Here you can see some typical agreements where you need to make sure to include confidentiality obligations. We have the confidentiality agreement or non-disclosure agreement itself, the NDA, employment agreements, development and cooperation agreements, contract research agreements, license agreements, manufacturing and OEM agreements, test agreements, sales distribution agreements, and what have you. These are just examples, as there are countless types of such agreements. And keep in mind that every time you share information that you consider a trade secret, you need to make sure that you have an agreement in place that ensures the other party is subject to confidentiality obligations. Today, I will focus only on the most basic one, namely the non-disclosure agreement, better known as the NDA. The NDA is your first line of defense, but it should not be the only line. If you share information without it, you may blow the novelty requirement and lose the chance to patent your invention, or you risk that your trusted partner suddenly becomes your competitor and steals your idea. The purpose of the NDA is twofold. First, to prevent spreading of the information, meaning that the recipient cannot share the information with third parties without your prior approval. This will prevent your confidential information from becoming public knowledge. Secondly, it shall prevent misuse by the recipients. In other words, that the recipients cannot use the information for any other purpose than the one intended. A typical scenario is when a big pharma company invites you to a meeting to discuss collaboration or even acquisition, but then decides not to continue the discussions. Later, you discover that they used your confidential information to improve its own product or process, or even to launch a new product based on your idea. The NDA is usually quite simple agreement, but you need to make sure that it contains all the necessary terms, namely a clear definition of what information will be shared, what it can be used for, often referred to as the purpose, who shall have access to the information, the confidentiality obligation itself and the duration of this. Preferably, the obligation is infinite, but often you have to limit the confidentiality period to 3 or 5 years, depending on the type of technology. It should have an obligation to delete or return the information when the purpose has been fulfilled or upon a request. And you may want to include a predetermined fine for breach, so-called liquidated damages, as it is often difficult to prove your exact economic loss. So let's say that for each breach, you have to pay 50,000 kroners or 500,000 kroners, depending on the value of the information. And remember that even if an NDA is terminated, the confidentiality obligation remains in place for the information you shared while the NDA was still in force. You cannot terminate that obligation. You can have a pretty standard NDA and just adjust it for each individual situation, so you don't need to spend big on a lawyer every time you need one. You can even download a template NDA from Bryn Aarflot's website for free, and then you are well on your way to protection already. But remember that even if you do have an NDA in place, limit the sharing to a minimum. Furthermore, you need to follow up with further agreements if the relationship develops into collaboration of some sort. And here I just referred to the list of examples on the previous slide. Since we'll send out this presentation afterwards, I included this slide with the terms I just talked about that need to be included in the NDA so that you have the lists. I've also included a link to the website where you can download the NDA template for free. We're already getting near the end of the presentation, but we need to talk about what control measures you can and should take to protect your confidential assets and most efficiently. As previously mentioned, a critical issue is when employees leave the company. It's therefore important to have a routine procedure for handling those situations. For instance, to have an exit interview to remind the employees of their continued confidentiality obligations. You should also have routines to make sure they don't take proprietary information with them, which is difficult since everyone now has company email on their phone and basically access from everywhere. You can also use non-compete clauses, where they cannot start working for a specific competitor, start competing business, or contact any of the company's customers or suppliers for a limited period of time. The flip side of that is that you may have to pay the employee during that period. There are a number of tools available that enables you to easily monitor the actions of your competitors and or partners, and to get notifications if they file new trademark or patent applications. And to some extent, you can also monitor their online presence. Such monitoring may reveal misuse of confidential information they have received from you or otherwise obtained. There are also tools available that alert you if one of your employees downloads large amounts of data or data they should not normally access. This can be very useful when some of your employees decide to leave your company to start a competing business. They would benefit greatly if they could bring some of your trade secrets with them to give them a flying start. And if you end up in a dispute with them, it will be so much easier if you can prove that they bulk downloaded the last 3 years of test results and project plans, rather than just claiming that they have used your confidential information in the competing product that they so mysteriously managed to get on the market in half of the expected time. You still have the option to secure evidence outside of court, but you will need a court order in order to do so. And from experience, the costs will immediately start to pile up. We did this exercise once when I was with Cisco, where the enforcement commissioner, also namsmannen, conducted a dawn raid in the offices and homes of a few former employees we knew had taken confidential information with them, but could not prove. The raid was very successful, evidence was secured, and the case was later settled favorably for Cisco. The automatic monitoring will have to be supplemented by manual monitoring, though. And the best way to manually monitor competitors and ex-employees is to engage your own employees. Make them read relevant publications, newspapers, and magazines, and not least report rumors they hear. Colleagues often continue to meet socially even if they no longer work together, and we all love to gossip. Take advantage of that. You can develop a company culture where the employees have a strong will to protect the company, and they can be responsible for paying special attention within each of the relevant areas. It is always smart to pay extra attention when people leave, especially if more people leave at the same time or hand in more or less identical resignation notes. Then you definitely know something is cooking. And trust me, I know from experience.
Yeah, and thank you so much for attending this webinar, and I hope we will see you again very soon. And thank you to Bryn Aarflot for this presentation, and Håkon, of course.